for the appellee, Bolt Shoes Incorporated, and we are discussing the legal issue, which is, does Bolt Shoes Incorporated have First Amendment protection for their claims? Were their claims and ads political in nature or commercial speech? And if commercial, are they protected? The parties of the complaint are, we are the appellee, and the other two attorneys are for the appellant. Okay, the facts of this case are that in 2007, Public Citizen, which is a nonprofit, private company, went and investigated conditions of workers in Bolt Shoes Incorporated factories across Malaysia and Thailand. They investigated through video footage and found that children were chained to sewing machines. Because of this, the appellee, the Bolt Shoes Incorporated, lowered by 30% their sales. They hired a private investigator to figure out what was going on. They went to those factories and fired the managers and took care of all of the wrong that was happening there. Bolt Shoes then sent letters to coaches in both Kansas and other states describing what had happened and describing where we were, that we still are providing opportunities and excellence work environments for people in these countries, and that our pay and our conditions are equal to all the other companies there, that it's a status quo and that we need that within those companies, within those countries. We disproved the false charges, and the factories continue to give opportunities. Bolt Shoes then ran full-length page ads in newspapers, both in Kansas and other states, stating some of the same things about our company and reiterating the fact that we have excellent work conditions and that we give opportunities to people in those countries. Public Citizen then sued Bolt Shoes, arguing that the claims that were made in those ads and letters to the editors were false advertising claims and that go against the Kansas statute 50-6262 and 3. And so we went to court, and Public Citizen claimed that they had new evidence of some of the work conditions, but that was never brought up in evidence. They just claimed that they had that. The case was dismissed by the judge at the district court level because the judge decided that the communication given by Bolt Shoes was political and of public importance and cannot be labeled commercial speech. Public Citizen, the appellant, has then appealed this, and that is why we are at the Kansas Court of Appeals here at Sterling College. Okay, so some cases have precedented the issue that we are examining right now, which is it political speech or commercial speech? Which our case got dismissed at the district court level because because the judge thought that it was political speech. However, we also want to examine the fact that if it's commercial speech, is commercial speech protected? So we've got a few cases that have kind of set this precedent for commercial speech and the protection of that. The very first case that kind of dealt with this was Valentine versus Christensen in 1942, where Christensen bought a boat and was hoping to charge, or a submarine, and was hoping to charge people to cross it. And he sent out an advertisement, but there was a law against advertising this sort of thing. And so instead he put a protest on the back of the advertisement, protesting the law, hoping that that would change it to political speech and then protect him. However, the courts decided in that case that advertising didn't have any First Amendment protection at all, and that commercial speech was not protected. Even though he tried to make it political, it was still an advertisement. So for a long time, many judges, courts, thought that this meant that there was absolutely no protection whatsoever for commercial speech. However, in 1964, in the New York Times versus Sullivan case, while they established a lot of precedents for libel, the case originated with a paid advertisement. And so this was kind of the first time that they thought, okay, well maybe advertising can be protected. However, it was considered paid political speech, and so it was a little different than our case today. So then in 1975, Bigelow versus the Commonwealth of Virginia happened, and it was another case kind of like New York Times versus Sullivan. However, it was a little different because it contained, or Bigelow's ad in the newspaper did more than just propose a commercial transaction, and it contained factual material of public interest. So this case established that speech is not stripped of First Amendment protection just because it appears in the form of paid commercial advertising. So they kind of reversed some of the decisions that were made in Christensen.
In Virginia State Pharmacy Board versus Virginia Citizens Consumer Council, the court established commercial speech was subject to some First Amendment protection with limitations that afforded to other categories of speech. In Central Hudson, Gas and Electric Corp versus Public Commission, the court reaffirmed that constitutionally of regulations forbidding untruthful and misleading advertising, as well as prohibitions on ads that promote illegal products and services. And this also established a Central Hudson test for other cases. In Sony versus New York, the Supreme Court kind of backed away from the standard of the advertising regulation must advance a state interest, though least restricted means.
Okay, and so the last one that we have is Nike versus Kasky, which the other people talked about and showed a video of Nike, which is not our company, and stated facts and about YouTube, that is about the YouTube, which is about the Nike case, that's not our company, or the appellee at all. And in this case, it was dismissed because Kasky was deemed not, he was a public citizen, so he didn't have stake into the claim. But Justice Sandra Day O'Connor decided and expressed the view that just because it was commercial message, which was buy our shoes, this is what Nike did in 2003, it was mixed with a political message, which was our political opponents are wrong. And just because it was presented outside a traditional advertising medium, which they did through press releases and just getting those facts out there, it should have been treated as fully protected. And so if Kasky had not been deemed not having a stake in the case, then it was in Malaysia, which is one of the factories that Bolt Shoes operates there. 3.2 million low-income workers have been given the country's first minimum wage, which is 900 riggins or $297 a month, which we match at our company because we match minimum wage. And the Prime Minister said the lowest paid will now be guaranteed income that lifts them out of poverty and helps ensure that they can meet the rising cost of living. And so that is what we have promised, and those are the excellent work conditions that we provide in Malaysia is standard with the country's minimum wage. And then our last thing is just talking about the fact that our prayer for damages is that we would like the court to once again dismiss this case as unconstitutional, and our protection is covered under the First Amendment.
All right, so questions?
So what makes your guys' speech political instead of commercial? Like what exactly makes you political speech?
We don't believe it is.
Okay.
We believe that it's commercial, but because it's presented outside of a normal commercial medium, and the fact that we've sent letters to editors and coaches and sent out press releases, kind of like Nike did, that it's commercial, but it's not traditionally commercial.
So you guys haven't done like TV commercials or posters or anything like that? Okay.
No. It hasn't been the traditional advertising medium that you would find. So we don't believe that ours is political. Okay.
We still conclude that this is commercial speech and it is not protected. In response to Ms. Lambert's compelling argument that that's not our company, we clarified in our previous statement that Bolt is a shoe wholesaler and sells multiple brands of shoes, and although Nike shoes were shown in the video, it doesn't mean that it was a Nike establishment. In addition to that, a direct quote from Brittany in their first case reference said that even though he tried to make it political, it was still commercial speech. They also referenced Central Hudson, which sets a precedent for our case by having created a test that says that is expression protected by the First Amendment. For speech to come within that provision, it must concern lawful activity and must not be misleading. We found Bolt to fall under both of those categories. It is not lawful, it is misleading. Additionally, in response to claiming that although their speech is commercial, it is not protected under the Kansas statute section 50-626 2 and 3, which is what we found them initially in violation of.
Do you have any recent evidence that shows that even after their claims, it has not changed?
The surfacing of the second round of pictures and videos and things as well is the same as, very similar to the first.
Do you claim YouTube to be a legitimate source for your videos?
We do, because our client initially found those videos through journalism, and they've later been uploaded to YouTube as a result of that. You can find any newscasts or things like that online.
We've seen it. We just decided to show it to everybody. That's why it's on YouTube.
I know what the YouTube channel was, like where exactly it came from. Who was the?
Yeah, got it.
There you go.
Right when you type in sweatshops, it is bits and pieces of some user with a bunch of CNN. So he seems to have just taken a bunch of links from CNN and placed them together.
Okay, so he likes to kind of rehash a lot.
So it's a news outlet.
A news outlet, yes.
Okay, CNN itself?
Not CNN itself, no. It's a user, but he's using a bunch of CNN stuff and pasting them together.
Do you know if he has any, have you gone through any of his other videos? See if he has any
Everything he's had, the first 4 links are all sweatshops. So he must have a fetish or a something for sweatshops.
Okay.
Okay, our closing statement will just be, and then we'll open for questions, is that we realized that we had a problem. We addressed that problem. We made retributions for that, and then we wanted to inform the public and inform the people that support us of what happened. And sorry, let me see this real quick. And we wanted to make sure that they understood where we were at. It was through these advertisements and this communication with the letters to the editors and the coaches and the newspapers that we wanted to just communicate the information. We wanted to express our opinion about it and then seek their support. And that's what we did, and that falls under the precedent of New York Times versus Sullivan. We have yet to see how what we did was not lawful or misleading, which is what was claimed against us. We have yet to see evidence of the new photos or anything of that. There's just claims of that. YouTube was not a source in this case at all. I don't know where that came up from. It was not put on YouTube. It's a private nonprofit, and so they found video on their own and then produced that in evidence, but it was not on YouTube or on any YouTube channel. This is not a moral case. This is the law and ethics of what we did as far as after the fact of realizing that there was something wrong with our system and then fixing that, and then what we did afterwards and deciding if that was unlawful and misleading. And we believe that it was not. We told what happened, and then we expressed wanting support from these different people that we sent the communication to. And this case is based on the claim of Kansas 50, Article 2 and 3, and that is the willful use in any oral or written representation of exaggeration, falsehood, innuendo, or ambiguity as to a material fact. And that was what we were sued over, that's what was dismissed, and that is what I believe we have proven again today, that we have not broken the law.